Well, welcome everybody. I'm Dan Slater. I'm the director of the Weiser Center for Emerging Democracies, WCED, and it is great to be back in person. We'll be doing it at least a few times this year. This is our first time back in quite some time, and we wanted to make sure with our very first occasion being back together that we'd have a chance to have our very own Brendan McElroy, who's been a postdoc here at WCED for over a year, but has only just arrived in person due to the pandemic. So first thing we wanted to do was make sure he had his chance to give a presentation before our actual live audience. So thank you so much for coming out for this. This is really great. So you'll see a lot more from Brendan in a moment, but he got his PhD in government from Harvard in 2020, and he is going to be joining the faculty at the University of Toronto Department of Political Science next fall, which we're extremely excited about. And I should also note at the beginning that this event is co-sponsored by CREASE, for the committee, council, the C, what's the C? The C is? Center. It is a C word. The Center for Russian and East European Studies. And also that this is the first event that we're having under our annual theme, which is going to be capitalism and democracy. And so if that's a theme that interests you throughout the year, we're going to try to keep returning to it as much as possible and think about the connections between democracy and capitalism, which is, I think, a pressing concern in the world at the moment. So without further ado, we do have a Zoom audience as well, I should say. So after Brendan gives his talk, we'll be both taking questions from the audience, and I'll also be on the lookout for questions from our Zoom audience. And so we'll sort of proceed accordingly. So it'll be a learning experience, a hybrid event, so enjoy. But this is, as you'll see, it's his remarkable historical research that Brendan does, and so everyone dig in and enjoy. So Brendan, with 12 feet of distance.
All right, so I am very happy to be here today and happy to see many of you in person. I've been told that as long as I'm up here, I'm allowed to take my mask off, and I know that many people are participating or observing through Zoom as well, so welcome to you. I hope many of you will be able to participate in the Q&A. Even if I can't see you or hear you directly. I'm going to present to you today some of my work on institutions, representative institutions, specifically property rights and economic growth, and looking at the relationship among these three entities, three concepts in the context of Eastern European serfdom and its demise in the late 18th and 19th centuries. And I will start off with figuring out how to work this thing. I will start off with this quotation by way of motivation, which even if I didn't attribute it, probably everyone would recognize. Basically, what Marx is saying here is that property relations or property rights, the structure of property rights in a society, can sometimes come into conflict with the requirements of economic development, right? Property rights that at one point may have fostered or promoted growth become fetters, to use his term. And at that point, what resolves this contradiction between a kind of progressive or pro-growth production structure and this fetter system of property rights, what happens is that you get a social revolution to resolve that. And if we look at great transformations of property rights throughout history, oftentimes they are affected through social revolution, but there are other modes of transformation as well. So sometimes the ruler or the ruling group manages more or less to impose a transformation of property rights on elites and masses alike. And sometimes these are negotiated more or less incrementally among the ruling elites, and sometimes with the participation of larger social groups and social constituencies as well. So kind of no surprises so far. But the question, which I don't think has really been asked in comparative politics or economic history, at least not with this frame, is what explains these variations, right? Why do great transformations of property rights sometimes assume a revolutionary form? Why are they sometimes negotiated? And why are they sometimes imposed? And secondly, one of the reasons we care about this is because presumably these different modes of transformation have implications for outcomes we care about, such as growth and equity. I'm mostly going to be talking about the first of the two questions, what explains such variations today, but the second is a focus of the book project, well, first dissertation project and then book project that this is a part of. So happy to talk about that as well during the Q&A. I'm going to be arguing in brief that the mode of transformation, right, whether you get revolutionary, negotiated, or imposed transformation of property rights depends, at least in part, on the availability of institutions, specifically representative institutions, that can actually broker exchanges of rights, pretty complex exchanges, exchanges that require some institutional support, and I'll go through the reasons for that later. I will argue that only certain types of representative institutions actually have the capacity to affect transformations of property rights in a negotiated way, right? And I'll argue, among other things, that this capacity of representative institutions depends on who in the assembly has agenda control, what decision rules are used, simple majority voting or something else. And it also depends on the monitoring and enforcement capabilities of the representative institution, specifically whether or not it has a permanent institutional presence in the form of a standing committee, in addition to an assembly that meets every 2 or 3 years and then dissolves and everyone goes home. So I'll argue that these factors help to explain why serfdom ended differently, again, in one of these 3 modes in different ways in various parts of Eastern Europe. So this is basically the region I'm looking at. The map is not quite updated because it's missing some of Pomerania and Mecklenburg up here. But broadly, it's the region between the Elbe and the Dnieper, so kind of the classic terrain of what is often called domain lordship, kind of large market-oriented production on large estates worked by a peasantry that is servile in the sense that they're subject to all sorts of legal disabilities. Most notably limits on movement, but there were many others, which we'll get into. And in terms of the time period, I'm mostly going to be looking at the late 18th century, sort of pushing into the very early 19th century a bit, and focusing on, does this thing have a laser? Focusing on this territory up here called Livonia, which today is, well, partly Estonia and partly Latvia, but in the 18th century was an autonomous province or territory of the Russian Empire, one of the western provinces of the Russian Empire. Just to, also by way of motivation, to give you a sense of what the stakes are here, even though the transformations I'm talking about specifically in this talk and in the dissertation, they don't cover the entire span of elimination of serfdom in the manorial system. That's a set of transformations that took a century, if not more. They did involve significant and in some cases radical transformation of the existing regime of property rights. So this is an excerpt from the first article of the Livonian Parliament or Diet's resolutions concerning serfdom, which basically forbade the sale of peasants, sale, donation, pawning of peasants separately from land. And then more systematically, I'll be focusing in this talk on this Peasant Code, which was passed in 1803 and enacted in 1804, and the transformations that it affected. So among other things, previously peasants in Livonia were essentially serfs. They did not have secure tenure on their farms. They could be evicted at will. Their obligations to the manor were pretty well undefined. For dispute resolution between lord and peasant, there was a very kind of unclear procedure with competing jurisdictions, and certainly there was no peasant participation in the process of resolving disputes between lords and peasants. It was all the lords. And there was limited freedom of movement. And things changed quite radically after 1804. Peasant farms became hereditary, and tenants got testamentary rights. They could choose which of their children would inherit the farm. Their obligations were normed essentially to the household's capacity to pay them. There was a formula using sort of size of land holdings and productivity of the land that was meant to ensure that peasants could pay their obligations and still have enough left over for subsistence and for grain marketing. New sets of courts were created to handle disputes within the peasant community, and a new appellate procedure was introduced to handle disputes between manorial lords and peasants themselves, one in which, importantly, there was peasant participation, and not just token peasant participation. I can talk about the details later if anyone is interested. One thing that did not change is that freedom of movement continued to be limited. That actually would not change for quite a long time in any of the Baltic countries, certainly not de jure, and de facto even longer it persisted. So those are kind of the stakes here. The rest of the talk, I'll sort of briefly go through the theory and the argument in the context of agrarian reform. I'll talk a little bit about the Livonian case. I will present some qualitative evidence that's more suggestive than anything, because it's hard to present qualitative evidence systematically in a presentation. Then I will present the results of some statistical analysis, looking at the preferences of Livonian nobles over agrarian reform, who supported agrarian reform and who opposed it, and what explains why what explains the division of parties, and then discussion. So theory, again, I'm placing this in the context, in the context of transformations of property rights and the relationship between representation, property rights, and development. And there's kind of a standard, I can't quite say consensus, but very popular, very widespread view of the relationship between these things in the political science and political economy literature. And it's encapsulated by this formula of the strong but limited state, right? Representative institutions, they are good for growth, and the reason that they are good for growth is because they protect property rights. They prevent the sovereign or the ruler from acting arbitrarily to expropriate, generally it's elites, but masses as well. At least that's the implication of this literature. And one of the oversights here, in my view, is that it doesn't really address the question of what do institutions do, or more generally, what happens when it's actually property rights themselves that are in conflict with the requirements of development, right? What happens when you actually, to foster growth, you need to get rid of an existing regime of property rights, or at least transform it radically? Is there any role for institutions in that process? And are they always good for growth, or might they sometimes be bad for growth, or just have no effect at all? And so this is a quotation from an agricultural historian, Peter Jones, who's talking about kind of agrarian development, or agrarian modernization in 18th and early 19th century Europe. And he says essentially that all the things governments were trying to do to encourage the spread of new crops, new crop rotations, new farm implements, new foraging systems, and the like, all of them touched upon the lord-peasant relationship in some way, right? There was really no area of agricultural policy that did not impinge upon the lord-peasant relationship in some way. And that meant that agrarian reform and agricultural reform hinged upon transforming the regime of property rights, right? The lord's property rights. Another problem with this kind of strong but limited formula is that, so in my view, it's pretty meaningless to talk about how secure property rights are without reference to political stability. If a country is on the verge of civil war or revolution, property rights are not secure, no matter how good the institutions look on paper. And I'm certainly not the only one to argue this. I should add as well that political stability, because it's a phrase that raises some red flags, it does not mean well, first of all, political stability is not a sufficient condition for growth, right? You can have a stable anti-developmental ruling coalition as well as a stable pro-developmental regime coalition. And in fact, one of the interesting questions that my work raises is why pro-developmental coalitions sometimes degenerate into anti-developmental coalitions, and I suppose the other way around, and what role, if any, institutions play in that process. But so for me, secure property rights are really about political stability in a specific sense. It means that there has to be a viable governing coalition, and it means that there has to be some mechanism, not necessarily institutionalized, but some mechanism to resolve the conflicts that inevitably arise between the constituent groups in the ruling elite or the ruling coalition. And it also means that you need a mechanism by which individual property rights can be abrogated or overridden when necessary, whether it's for social good or development or some other reason. Because property rights need to actually change and evolve to continue to be good for growth, right? They can't remain static. Social change happens, technological change happens. Again, this is kind of one of the core insights of Marx and others, that property rights, the legal regime of property rights, has to adapt to cope with transformations in the social structure and the technological situation and so on. So I'm arguing that we have to rethink the contribution of representative institutions to growth. Instead of focusing on how they constrain the executive in the context I'm talking about being a monarch usually, we should think more about their role in making and breaking ruling coalitions, and making and breaking specifically pro-developmental ruling coalitions as opposed to anti-developmental ones. And under this rubric, the functions of representative institutions that are important are things like, as I mentioned, dispute resolution, whether they can actually enforce collective decisions, right, that the rights holders make, and brokering exchanges among coalition members to basically generate or benefit from gains from trade. Right? These are things institutions can, under some circumstances, do. The forms of evidence I'm going to present to you to support these claims are twofold, so I will briefly go into an archive-based reconstruction of the Agrarian Reform process in Livonia, and then I will present and do some analysis on an individual level data set of noble preferences over agrarian reform. So to my knowledge, the first, or at least one of the first, kind of individual level data sets on the preferences of landed elites themselves, right, over something like agrarian reform. The findings to preview are that representative assemblies, or some of them, could foster development by acting essentially as markets for the exchange of property rights. I'll talk more about what this means, but essentially it's about, in part, capturing gains from trade, right? If you have institutional support for complex exchanges of property rights, you can actually make those exchanges that quite possibly benefit many different parties, which you might not have otherwise if the representative institution didn't exist, or if it had a different set of internal decision-making institutions. And I'll argue that there are specific institutional attributes that make these exchanges possible, among which one of the most important is majority voting as kind of a simple and easily observable decision rule. Majority voting that has some finality to it. In terms of theory, the contributions are several, but first, we get kind of a new explanation for the abolition of serfdom in Eastern Europe, or more specifically, why it was abolished in different ways in different parts of Eastern Europe. And then I see this as a step towards understanding the politics of bad property rights and how we get rid of them. Again, a lot of the literature on property rights just focuses on kind of good property rights, but there are, as I've said, bad property rights that you need to get rid of in many times to generate development, certainly equitable development. So how do we actually get rid of those? Okay, so as I said, I'm going to be talking about this in the context of Eastern European serfdom, and this will probably make a little bit more sense once I spell out, what I'm talking about when I mean property rights, the lord's property rights in this case. So it has to do with thinking about serfdom as a system of property rights, one that encompassed the lord's rights and obligations to do things like demand certain goods and services from his tenants, his theoretical obligations, at least, to provide for subjects, and the label conservation was often used, which gives you a sense of kind of the nature of the rhetoric and how this was perceived. It was, basically preserving the peasantry as a natural resource so that they can continue to be exploited. But also the lord had obligations to perform delegated public functions, collect taxes, administer justice, often administer poor relief, things like that. And serfdom also encompassed the peasants' customary or use rights, which were usually much less well defined, and so for that reason, probably much more subject to violation or abuse. In theory, they did exist. And you can see, again, when I talked about delegated public functions especially, there's a sense in which the serfdom as a system of property rights, it contains both what we would now consider, recognizable ownership rights, right? The right to do what you want with your property, but also the rights of rulers, jurisdiction. So there was a kind of public aspect or public function to it as well, to this relationship. And it's interesting to note that I was reading a book by an English historian on kind of the history of eminent domain in Western Europe through the Middle Ages and early modern period. And one of the points she makes is that a lot of medieval political writers used the same word basically to talk about all forms of property ownership and jurisdiction. So, dominium and its variants. They would talk about, the dominium of a ruler, jurisdiction over his subjects, and the dominium of a property owner over his land or movables or whatever. So dismantling this relationship, dismantling serfdom, meant kind of removing the public aspect of this relationship and converting it into a purely contractual one, which is certainly not to say an egalitarian one or a fair one by any means, but one in which the parties are legally free and equal in the manner of kind of bourgeois property rights, the classic idea of civil society. More concretely, you can get a sense of what the reformers' goals were in terms of agrarian reform, agrarian transformation, by looking at their own words. So these are quotations from 3 Livonian nobles around 1800, all supporters of agrarian reform. And you can see they kind of formulate the goals of agrarian reform in remarkably similar terms. There is no talk here about the wholesale abolition of the lord-peasant relationship. Certainly few lords, if any, ever advocated that. But there was this idea of giving more rights to the peasant under the system of hereditary subjection or peasant subjection, right? So especially securing peasant property rights, tenure, protecting him from arbitrary treatment, and regulating his obligations to the state and to the manorial lord so that he could not be arbitrarily, I'll use the word taxed, but taxed in a sense by a private individual. And then there's clearly the kind of Enlightenment, humanity sentimentality about treating them as our fellow men, which occurs pretty frequently in these discourses as well. For comparative purposes, I'm defining agrarian reform as sort of state policies undertaken to improve the peasant's condition by doing one of 4 things: strengthening tenure, making sure the peasant has secure tenure on his farm; regulating his obligations to the manor, to the lord; ensuring access to justice. So part of the background here is that one of the public functions of landlords in many East European countries was that of administration of justice. So they had manorial courts in which the lord himself or one of his agents sat as judge, with obvious potential for abuse. So ensuring access to justice means basically regulating these courts and ensuring that peasants can appeal decisions to royal courts, or courts not under the control of the landlords, at any rate. And then 4th, abolishing manorial controls over peasant movement, and I should add, a whole bunch of other controls over demographic behavior, marriage, and so on. all of these policies impinged upon the nobility's property rights, right, as defined previously. And so for sovereigns, for reform-minded monarchs, or really for anyone who wanted to transform this system, but especially for the monarchs who wanted to transform it in a non-revolutionary way, they faced kind of a choice or a dilemma. You could proceed in one of two ways with agrarian reform, which I'm calling negotiated and imposed reform. It's a distinction that matters for outcomes, including the likelihood that these reforms are actually implemented on the ground. Probably won't have time to talk about that, but it's something we can talk about in the Q&A. So I'm defining negotiated agrarian reform as essentially cooperation between the nobility, the landlords that is, and the crown, the government. There has to be kind of an institutionalized bargaining and then reform settlement reached between the crown and the landed elites. And so this is a more specific operational definition that negotiated reform involves the nobility or the landlords taking part in the drafting of proposals, giving their collective or corporate consent, right, consent as an institution, as a parliament, as a diet, as estates, to the reforms, and then usually assisting in their implementation as well. Not being the sole implementers, usually it's kind of a joint effort between royal bureaucrats and the noble landlords. This is a sort of, I don't know that I would call it a decision tree, but kind of quasi-decision tree or fake decision tree showing the different possible outcomes and how you get to each. So in this sort of stylized scenario, the crown starts by initiating negotiations with the estates or choosing not to. If the crown basically decides to just try to do what it wants, not consult the nobility, not consult the estates from the beginning, that's a first variety of imposed reform. But in many cases, the crown did try to consult the estates or win their consent for some agrarian reforms. And that in turn generates, a few other outcomes. If the estates actually respond favorably to reform proposals or don't, reject them all immediately and categorically, there's the possibility for continued negotiations, eventually leading to a negotiated settlement. Of course, it's possible that somewhere along the way in the negotiations, in the process, the negotiations will be interrupted, often interrupted by some crisis that causes the crown to take unilateral action. So some peasant revolt or discovery of, unsuspected, at least unsuspected by the rulers, abuses on certain manners that make them think that they have to act swiftly and so by necessity unilaterally. On the other hand, earlier in the tree, if the crown presents reform proposals to the nobility and they just reject them out of hand and show no willingness at all to compromise or to even entertain the proposals, then you have the decision of the crown to proceed without the nobility's consent or to basically give up on reform. So they could give up on reform, in which case nothing happens, or they could decide to override the nobility, the elites, and try and proceed to implement their own policy preferences, basically. And so that's a different variety of imposed reform, just helpfully numbered here to indicate that they're not all the same outcome. You get to them in different ways. Because this is sort of the reference point for this is Eastern Europe as a whole, I just want to point, and because people probably have different historical reference points, I just want to point to a few kind of paradigmatic cases of the different modes of reform. Again, here, the outcome I'm interested in is Livonia, 1804, this negotiated reform. And then there are many more ways you can get to either no reform or imposed reform. So you have different varieties of imposed reform in Hungary, Bohemia, and Galicia after annexation from Poland. And then you have cases like East Prussia, where there is some sort of sporadic discussion of agrarian reform, but before 1800, at least, nothing really happens. So you don't get any substantial reforms. So the question is, I'm going to focus at least on the distinction between imposed and negotiated reform here. So the question is why you sometimes got one outcome and why the other. Why in some Eastern European polities do you get negotiated reforms, like in Livonia, and why in other places does the process assume a much more kind of coercive aspect, where it's the crown certainly coercing the peasants, but also coercing the elites. And to explain these variations, I'm going to kind of advance two hypotheses. First, I want to point out that the preferences of landed elites over serfdom are not uniform. And a lot of the historical literature and then some of the recent economic literature on serfdom or labor coercion too, kind of just treats the nobility or large landowners as a single actor. They all share preferences. But if you read sort of closely in the historical literature and if you think about it a bit more, you can see that large landowners often have reasons to support limited agrarian reform. Again, the key word being limited. Often what happens is that you have large landowners who are absentee owners because they own so many different properties that they can't possibly supervise all of them at once. And so the day-to-day management of the estates is turned over to administrators or foremen or agents or whatever the term is, basically their employees who are supervising the running of the estate. And that causes a pretty acute principal-agent problem because the proprietor and their agents often have different incentives, right? If you think about a short-term leaseholder of an estate versus the proprietor, right, hereditary proprietor, it's possible at least that the short-term leaseholder will basically be interested in extracting the maximum profit from the estate in their 6 or 12 years or whatever, which often does harm to the estate's viability over the long run, even though it may boost profits in the short run. Whereas the proprietor, conceivably has longer time horizons here. So that raises this principal agent problem, to which one solution is essentially third-party enforcement, state enforcement. So this is just one of several rationales you see for large landowners supporting agrarian reform. I'll talk about others too, but this is just to kind of give you an idea of why the preferences of large and small landowners who manage their estates directly, they don't have this problem, might differ. And then at kind of a more macro level or polity level, I am going to argue that negotiated reform happens when representative institutions are, for lack of a better word, manageable, which means that they're able to make collective decisions that are in practice binding upon all of their members. So that involves a few things. It involves the institutions having the ability to solve agency problems in the first place. That's in the process of actually negotiating these reforms, these transformations of property rights. All sorts of agency problems come up, and the characteristics of the assembly or the institution matter for whether it's possible to solve them. And then also the ability of reform opponents, because everywhere there are reform opponents, to obstruct proposals. And this depends, I'm going to be focusing in particular on majority voting here, depends on the decision rules that were used in the assemblies. So not all of these East European kind of early parliaments or early representative institutions, not all of them used simple majority voting as a default decision rule. And I'm going to argue that those which did were actually most likely to get negotiated reforms. In cases where the decisions were traditionally made by consensus or by some sort of supermajority rule, or often there was some kind of curial system, whereas different parts of the elite had weighted votes. Those are situations in which reform opponents are more likely to be able to obstruct reforms indefinitely. And so when that happens, negotiated reform is impossible, and you will get either, or tend to get, either imposed or revolutionary transformation of property rights. So again, to clarify or to reiterate, you get negotiated agrarian reforms when representative institutions are dominated by large landowners, actually, rather than small landowners or kind of petty nobility. When I say small landowners, I don't mean peasants. I mean petty nobility, small landholding nobles. And negotiated reform is also more likely when you have what I'm calling manageable representative institutions. They tend to be unicameral, have simple majority voting as the default decision rule, and they also tend to have kind of a permanent institutional presence usually in the form of a standing committee or directorial committee, because these representative institutions, for the most part, they were not in permanent session. They met for a few weeks and then everyone went home and they assembled again the next year, or 6 months later, or 3 years later, or whatever. So in places where there was a standing committee that could actually carry on the work of the assembly in between full sessions, monitor the implementation of reforms, and coordinate with the government to oversee implementation, those are cases in which you're more likely to get successful negotiated reform, I'm arguing anyway. Research design, there are a few different ones that I use in the dissertation/book. There's a comparative analysis where I use time-varying measures of different modes of agrarian reform in about 25, 26, 27 East and Central European polities, looking over most of the 18th century. The significance of 1806, because I get asked this a lot, is that it's the end of the Holy Roman Empire. It's not just a random year that I picked. And then I also process trace the abolition of serfdom, or the reform of serfdom anyway, in Livonia during the last decade of the 18th century, continuing into the first decade of the 19th. And the process tracing serves a few different functions. It allows me to test predictions not only over the outcomes, but also predictions related to process, right? So do we see that, in fact, it was large landowners who were the supporters of reform and small landowners who opposed them, right? Things like that. And the kind of key finding here, what I'm going to try to convince you of, is that to understand this sort of process of negotiated reform, you really need to understand the structure of noble society, or past conflicts within noble society, how past conflicts over wealth and especially sort of rank and status shaped the alignment of parties on questions of agrarian reform. Because, at least I'm going to argue, that you see a correspondence between these previous divides, conflicts over status and rank, and the parties that pop up in the conflict over agrarian reform. So again, in terms of process, these are some of the things we should expect to see. We should expect to see this correspondence between sort of rank or status within the nobility and support for reform. We should expect to see opponents basically try and challenge the validity of majority decisions, say that in matters of property rights, majority decision is not valid. You need common consent. Read the consent of every last one of us if you're going to do anything, or at least the consent of a supermajority, and so on. And you'll see supporters attempt to use the manageability of representative institutions to their advantage. They'll exploit agenda control. They'll exploit the decision rules that the assembly has to try and, push or turn the outcome in favor of negotiated reform. To understand the Livonian case, you need to get a little bit of context first. Won't be all that much, but so here's the Baltic provinces of the Russian Empire around 1784. Oh, oops. This is Livonia here, and this is what was then the province of Estonia, which is much smaller than the present-day country of Estonia. But what's important to know here are a few things. First, it's a case of domain lordship, right? It is an agrarian society in which you have mostly market-oriented production on large estates. And there are free laborers, wage laborers, who are important, but they're actually less important in Livonia in the 18th century than they were in most other parts of Central and Eastern Europe. So I feel reasonably comfortable saying that, kind of servile peasantry was the basis of labor supply in this case. So most peasants have this legal status of serfs, or in German, Leibeigene, which I'll talk about what it means. They are liable for unlimited labor services. The lords can demand as much as they want from them, whenever they want, and in whatever form they want. Their tenancy is at will, meaning that, at least in theory, they can be evicted at any time, whether it's for a thing like incurring debts or non-performance of obligations, or just for whatever reason, right? So often what would happen is that you would have a good peasant householder, one who is skilled at managing his farm, doing a good job, and then the proprietor, the landlord, will take his farm away and transfer him to a farm that was badly run so he can work the same magic on this badly run farm and improve it. And then presumably, when he's done that, turn him over to a different farm and do the same thing again, essentially ensuring that he doesn't reap any of the benefit of his investments and skills. And these peasants, serfs, are subject to manorial courts, which have police functions, civil functions. They don't have really functions in criminal law by the 18th century. They did earlier. But still pretty expansive jurisdiction. And they have limited freedom of movement, as I said. And this is very much not a static society. I want to emphasize that it's one that's changing rapidly in the 18th century, specifically after around 1760. So this happens everywhere in Eastern Europe. You start to see kind of the land market reviving. Estates become more and more commodified. The trade in estates livens up. The landless and semi-landless population begins to grow very rapidly. And there's kind of a boom in land prices and rents and prices of farm products as well. So this is kind of the background. That's background to these reforms in Livonia and elsewhere. There are problems cropping up that force the elites in the government and the nobility to take some kind of action, or at least make it desirable to take some kind of action. And in Livonia, what happens is that basically the government, the imperial government in St. Petersburg, asks the nobility in their representative institution called Diet, Landtag, in 1795 to discuss agrarian reform proposals. These discussions drag on for a long time, both because of foot dragging by opponents and because this is a period in which the Russian Empire goes through 3 successive czars, so there's not always exactly continuity of policy in St. Petersburg. At this sort of reform diet or important reform session in February, March 1803, the Livonian Diet approves this big reform package. After some modifications, it enters into force in 1804 as Peasant Code, with German and Estonian and Latvian and Russian names. And by the fall of 1805, the implementation of most provisions is complete. There's a land survey that begins later and actually continues until like the 1820s, actually continues after nominal legal emancipation. But I say implementation is completed in fall 1805 because there were provisional registers of peasant obligations using the new principles that were issued to all manors. Right? So in theory, peasants should have felt the effects of that aspect of the reform as well as the others pretty much right away. Provisions of the Peasant Code, I've already talked about this, basically. Hereditary tenure, dispute resolution. There aren't that many studies, kind of micro-level studies of its effects. There are a few by Soviet-era scholars, Soviet, Baltic historians, basically, and the best one, interestingly, found that the reform, it normed obligations to the household's capacity to pay, which overall meant like a 10% decrease in the value of peasant obligations to the manor. But its effects were very heterogeneous. On smaller estates, the decrease in obligations was much bigger. And on large estates, the effects were minimal, or sometimes the obligations actually increased. Right? Again, that's not to say the reform didn't matter, because there were all these other provisions too. But that gives you another sort of intuition into why different, wealthier and poorer landowners might have had different preferences over the reform if they could kind of anticipate this happening. And then there's a comprehensive land survey. I'm going to try and proceed a little bit faster here since I'm running out of time. Livonia, for our purposes, what you need to know is that it was essentially governed as a separate country. It had its own laws, its own institutions, its own agrarian structure, its own nobility, which spoke German and was Lutheran. So kind of an autonomous territory within the Russian Empire. And because the social structure of the nobility is important, we're going to have to get into the weeds a little bit. Basically, the landed nobility is divided into ins and outs. So there's this group called the noble corporation, which is a very awkward translation of a German collective noun that we don't have a good word for. Knighthood, I guess, in English. these are the inns. These are basically older, wealthier families of nobility, and they're all listed in this register of families called matricle, which this is important, it'll come up in a few minutes. And then there are the outs, this group of noble landowners and a few bourgeois landowners outside the noble corporation, who have different names, sometimes called Landsassen, sometimes non-recepti. This is a common pattern in a lot of East European polity, is this division between kind of an in-group of nobility and an out-group. You have the provincial diet, which is an assembly of noble landowners, specifically an assembly of noble landowners listed in this thing. Noble landowners who do not belong to the corporation have much more limited voting rights. You have the diet's executive branch, a standing committee, which is called the College of Councillors, Landratskollegium, which is essentially kind of a standing committee, steering committee. It's kind of hard to relate to modern categories of division into legislative and executive and judicial because it had all three functions, as did the diet in certain ways. So it is somewhat confusing, I understand. And the social background of the reforms, which remember happened in 1804, is kind of the resolution, or at least short-term resolution, of this divide between in and out groups of the nobility. So what happens is in 1797, there is as you see here, this very sharp increase in the number of families in the registered nobility, or the corporate nobility. Basically, they admit a whole bunch of families that had previously been excluded, partly under pressure from the central government, partly because of various institutional changes in how the province was governed that I'm not going to get into. But basically, so that's kind of the social background here, right? You see this big increase in the size of the noble corporation, the nobility that has political rights. And so this is to say that these tensions between old and new nobility at the time are very acute, right? It's not sort of a division that was overcome decades ago or that's at the back of people's minds. It's something that was, very controversial and was still being felt, in the period that reforms were under discussion. And just for comparison, here is Estonia, where no such kind of mass admission of new nobles into the corporation occurred, just to show you the magnitude of the change. The qualitative evidence, which I'm going to speed through, unfortunately, is based on archive-based fieldwork in Russia and Latvia, and forgot to add it to the slide, but since Estonia. I examined a whole range of different materials, including the imperial government's, the papers of the imperial government's commission that was responsible for overseeing and implementing the reform, correspondence, and then especially petitions, minority opinions, letters, and so on that were delivered to the 1803 Diet by Livonian noble landowners, right? That's how I sort of get their preferences out. And then some other sources as well. Here are examples of what they look like. The point that I'm going to try and convince you of in terms of qualitative evidence, briefly, is that the supporters of agrarian reform also, tended to be recruited from the higher nobility. And if you look at what they are sort of arguing, they offer a very kind of aristocratic, it's strange to say elitist when the sort of poorer nobles are still unquestionably elites, but even more elitist vision of representation and belonging. You'll also see evidence, anecdotal here, but I can produce much more if you'd like, that the Reform Party was very interested in defending the binding character and the finality of majority decisions, because this became contested when opponents of agrarian reform challenged the institution's ability to do this. They said, no, matters of property rights, this touches us too closely. You can't expropriate us or reform our property rights by a simple majority. We have to give our consent to this, right? You need common consent. And this is the broader point I will try and convince you of. So again, these are selections from the writings of two reformers here, two of the most prominent agrarian reformers, who are talking about their vision of representation in the Diet. The first is addressing a proposal, this is George Bach, is addressing a proposal that would allow only the ill-defined best or most experienced members of the nobility to actually take part in the diet. And what he says is essentially, a selection from the whole will accomplish much more than the whole itself, right? And then here you see a very sort of similar set of views expressed by one of the leading reformers, Buddenbrook, who is responding to a proposal to increase the quorum requirement for the diet, which was very low. It was 32 people, to 2/3 of all the members who had been invited. And he says, essentially, the quality of the diet's decisions, it doesn't matter how many people are here, it matters the quality of the people who are here. In other words, if you have the right people, the old families, the respected families, even if they're few in number, they're going to make better decisions. So even by kind of noble elite standards, fairly aristocratic. And then this is just a kind of an example of the anti-reform or the conservative rhetoric or discourse that was used. It's a petition that was signed by a bunch of Diet members, and they say, essentially, we refuse to be bound by majority decisions if we don't like them. And again, claiming as the rationale the idea that property rights can't be abrogated without the consent of every last one of us. Can't be abrogated by simple majority, even if it's for common good or some other public purpose. Again, that's anecdotal. I can present much more evidence. Hard to do in a talk. I will very briefly go through the quantitative results. So based on these petitions and letters, I put together a data set of 104 members of this diet held in 1803, which is about, it's not everyone who attended, but it's about the median number of votes that were cast in divisions. So there's reason to think it's representative. And it's about 40% of all manorial land in the province that's represented here. So again, not everyone. I mean, many people didn't attend to begin with, but a large slice of the elite here. And then this is just one of the interesting kind of things here is that you can see the number of votes cast goes down very rapidly as the assembly goes on longer because people are going home. Because it's these landowners attending in person, and they don't want to stay. They want to go home and manage their estates. Riga's expensive, and who knows what the overseers or the administrators are doing back home. Anyway, this is what the list of signatures kind of look like, and this is me decoding them. So this is just basically to give you a sense of what the petitions and the signature lists look like, kind of the raw materials I'm dealing with. Basically, I identify all of these people on the basis of signatures. And I try to measure status or kind of rank, prestige, call it what you want, in noble society in a few different ways. Land ownership, how prominent a place a person or a family has in this matricle, which again is the list of kind of old families, old registered families. And then whether they've served on the nobility's executive branch, the College of Councillors, which by all accounts was kind of the center of the pro-reform but also pro-aristocratic party in 1803. And then age and origin of noble title. I have a bunch of covariates as well. I'm really running over time, so I'm not going to go into this in as much detail as I would like, but this is an example of the sort of information I have for every one of these 104 people. A bunch of covariates, how far away they were from Riga, university education, the age of their title, amount of land ownership, and so on and so on. Descriptively, this is sort of plotting different measures of status against one another. We have 4 different groups of nobility, ancient nobility being the most prestigious, going down to nobility of the Holy Roman Empire, Briefadel, which was the least prestigious. We have different positions in this matricle, and then the size of the dot represents the size of landholdings. So you can see there's obviously correlation between all 3 of these things, but there's enough variation within each category that I think it is fruitful to measure them jointly, put them in the same estimations. Again, descriptive. Here are results on some of the explanatory variables of interest. What this shows you is that the reformers, on average, were, the dotted lines are group means, dashed lines. The reformers were considerably younger than the conservative members of the nobility. Interestingly, there wasn't really much difference between them and conservatives in terms of how prominently they were featured in the matricule. But there is a big difference in terms of land ownership. The reformers, on average, have much more land, or considerably more land anyway, than the conservatives. And these are effect estimates from various estimations, just to show you that the results hold up in kind of a multiple regression framework. You find the same thing. Membership on the College of Counselors, interestingly, in most estimations is positive. So the members or former members of this standing committee, that's one of the strongest predictors of supporting agrarian reform. Also, the different types of service in local institutions matter, but I'll talk about that later. On to the discussion, the actual discussion in a second. What I've tried to do here today is at least present part of a new framework for talking about and thinking about the relationship between representation, property rights, and growth. I've argued that the social structure of elites and the design of representative institutions influences the mode in which property rights transform. I have argued that when you have what I've called manageable representative institutions, you're more likely to get negotiated change. And when institutions are unruly, unmanageable, in the specific sense that I've used the term, you're more likely to get either imposed or revolutionary change. So thank you for your attention. And yeah, I think Dan is going to be moderating both the in-person Q&A and the virtual Q&A. Is that right?
That is right. So
okay.
if anybody in the room has a question, Derek will be coming around with there's Derek with his microphone. And if anybody, hello Zoom crowd, if anybody who is on Zoom would like to ask a question, you can type it into the Q&A, and I will be a purveyor of questions if time permits. But I'm going to go ahead and I have a mic, so I'm going to ask the first question. So I could it's spectacular research and totally fascinating. I could use a little more help in figuring out whether this contradicts or confirms what I think I already know about land reform. Okay, so when I think about land reform in parliaments, I think about Sam Huntington saying that parliaments are the graveyards for land reform.
Yeah.
And I think about Mike Albertus arguing that autocracies and basically are the only way you get around all the veto players who prevent land reform from happening. And so what I'm wondering is the way you're thinking about institutions here, is it through the move to say that these are decisive institutions and it's not about constraints, and therefore your account is sort of consistent with that vision? Or is it the case that what it means to do land reform has changed so much over time that it's a different beast?
Yeah.
Could that be what's going on? And could it also be the case that because these particular large landlords are supporters of such limited land reform, that institutions might flip? So in the sense that for lack of a better word, a strong parliament, a manageable parliament, might be on the one hand conducive to limited reform, but be precisely non-conducive to more extensive reform. Is that possible? So if you could help me on that, that'd be great.
Yeah, so to address the first question, the work of Mike Albertus is obviously a major reference point for mine. I hope that showed through at least a little in what I said about my work. I would say there's nothing in here that really contradicts Albertus's argument, but the contexts are so different that I wouldn't even think of applying. I mean, I did think of it, but I don't think it makes sense to apply kind of the Albertus argument, its assumptions and conceptual categories to the context. Like, he's talking about land reform meaning the physical transfer of landed property. And for me, agrarian reform it's a much broader set of transformations of, not just land rights, land ownership, but the whole sort of position of basically how public power is organized even, right? The transition from a society in which these landlords have all sorts of public or quasi-public functions, to one in which they are just landlords. They may still have a lot of informal authority. They may still be rich. Again, not to say that a society in which agrarian relations are contractual is an egalitarian one by any means, but it's different at the very least from the kind of agrarian society in which landlords legally have this authority. So that's how I would answer the first question. Yeah, so one of my ambitions, at least for the book project, is to pursue the development of these reforms over the long term, because, as you suggest and as I hinted too, right, the work of abolishing serfdom and dismantling the manorial system, it took place over, in most cases, decades, if not hundreds of years. In some of the revolutionary cases, it happens very fast, but in Eastern Europe, there are not many revolutionary instances of transformation, at least this aspect of property rights. So I'd at least entertain that as a possibility. I cannot answer that question definitively. That would certainly make for kind of a neat, interesting argument if, in terms of agrarian reform, it's a certain type of institution that gives you early advantages, but later disadvantages, and might lead to worse outcomes. So something that's definitely worth investigating, and I would not rule out at the very least.
My name is Adam Casey. So thanks for a great talk. I have 3 very short questions. So were there any perceived productivity benefits from agrarian reforms from landowners? And if so, were there perceived economies of scale to those productivity benefits? Second, how much did these elites know, real or imagined, about other agrarian reforms elsewhere? It doesn't have to be real information, but just sort of their various myths about how it had gone somewhere else.
Yeah.
And then third, how much, so you kind of present right at the end, and it's unclear if this is missing signatures or missing data. So how much manorial land was outside the Diet, and how did it look in comparison, if you can even find this out? Like, this might be more or less impossible to know, but I'd be curious if there's any systematic differences between manorial estates that were not actually included at all in the Diet versus those that were.
Yeah, I can address all of those. So first, I didn't go through all of the arguments that were advanced for agrarian reform by any means, but in kind of the classic, liberal institutionalist framework, the incentives-based arguments were some of the important ones advanced by supporters of agrarian reform. They would say, well, how can we expect the peasant to invest in his property and try and boost output and productivity and become a better farmer if, as a result of doing that, he's going to get his land taken away and he's going to be transferred to another farm to do it again. So all these sort of classical liberal arguments about incentives and property rights do show up. I should even say proto-liberal in this context, since it's, this is not pre-Adam Smith, but it's pre the reception of Adam Smith in the Russian Empire. So maybe proto-liberal is a more appropriate term. Second, it's hard to tell, and I don't think, for the most part, I don't think they knew very much. In the writings of reformers and conservatives, you find occasional references to the other reforms. So there's one petition I'm thinking of signed by a bunch of pro-reform figures that talks about Denmark, where serfdom was abolished in 1788, and says, the results of that were great, right? Like, land increased in value by 100% in the next 10 years. We can expect the same to happen here. So most of them I don't think had much information about agrarian reforms elsewhere in Eastern Europe. That would change later on, where the Prussian emancipation in particular became a model. But at this point, they know a little bit, but certainly there are few, if any, experts who could sort of systematically go through what all the different East European states had been doing in terms of agrarian reform. And then the third, so it's the 39% that's the amount of, or the percent of manorial land owned by these 104 Diet members. The rest is not missing data, or I guess it is in a limited sense. So the remaining 61% is a few different categories. There were a bunch of nobles who just did not attend the Diet, even though attendance in theory was obligatory. and there were fines for not attending, but they didn't show up. Absenteeism was pretty high. Again, these things were expensive to travel to and attend. So that is, in a sense, missing data in that I don't, they weren't at the Diet, so I don't have their signatures on petitions. I can talk about how I think that affects the results, if you'd like. Then also, not all of the land in Livonia was owned by local nobles. The state or the crown owned land. Parish priests owned land. A lot of land was owned by basically, high-ranking Russian bureaucrats who had estates all over the empire and, were extremely wealthy and played a role in court politics, but local Livonia politics, nope, probably never set foot in the province. Something that's interesting to note on the question of absenteeism, I can get us back here. Oh, I'm actually going in the wrong direction, is that arguably the fact that this was an assembly where people attended in person instead of electing representatives who then attended, arguably that was kind of something that favored the wealthier landowners or the aristocrats, right? Because poor landowners could not often afford to attend in person, or if they did, right, a lot of them, you can see, leave early. And again, it's not just poor landowners who are leaving early, but I think disproportionately, they are the ones who don't attend and who leave early, if you just sort of compare the figures on land ownership for these people and general figures we have for the whole province. So you can definitely see, too, comparisons with other cases. There are many places in Eastern Europe where representative assemblies were assemblies of elected delegates. And those were actually very bad for agrarian reform because of the prevailing concept of representation. Most of these elective representative institutions operated on the basis of like an imperative mandate. The representative received detailed written instructions from their constituents, which they could be recalled for violating. And if they violated them and then went home after the fact and their constituents found out, they could say, you acted illegally, we did not actually give our consent. So kind of withdraw consent ex post from an agrarian reform resolution or any sort of resolution for that matter. So yeah, those are all things that are worth considering, definitely.
You had a question? Okay. Question in the back, and then I'll come over there.
My name is Junda Liu. Thank you for sharing the research with us, Brendan. I have a question about the manageability of the representative institutions. You stress the importance of simple majority ruling, simple majority voting. First question is, what were the alternatives? Were the alternatives no voting at all or very complicated voting? And second question was, what was the mechanism of why it was important? Was it due to expertise threshold, or was it very important in terms of alliance making, or was it, if it's a whole set of very complicated rules, multiple rounds of voting, that would reduce efficacy? What was the mechanism there?
Yeah,
Thank you.
So some of the alternatives to simple majority voting are, often decision rules were kind of vague. So there was just this idea of common consensus. In Hungary, the lower house of the Diet in Hungary, the speaker, who was a royal appointee, basically the lower house of the Diet in Hungary, they rarely counted votes. There was a debate, and then the speaker, who was a royal appointee, announced the resolution as he interpreted the outcome to be. And this is, again, a sort of a society in which people accept that votes are weighted, not counted. So the wiser, supposedly more educated, richer members of the nobility, their votes might be given extra weight. Or they might be given less weight, depending on who is the speaker. I would say the two main alternatives to simple majority voting are consensus and then some kind of supermajority or curial decision rule, where you have votes being cast, but the units are not individuals. It's like different territories each get one vote, even if they have different population of nobles and population of non-nobles and so on. And so you're interested in the mechanism by which these majority rule led to negotiated outcomes. Yeah, for me, it is a matter of basically like the decision-making efficiency of the Diet. We don't have a word for it in English, but in German they say like Entscheidungsfähigkeit, like capacity to make decisions that are recognized by all members as binding upon them, right? So when you have a tradition of majority rule and it's well established that Parliament can do things like expropriate property for public purposes, you know, to build a railroad or to build a turnpike or canal by majority vote, you're at least more likely to have that be accepted when what's on the agenda are these bigger transformations of property rights. And it is also just a matter of hold up, right? Famously, the Polish parliament, or the lower house of the Polish parliament, had this rule called liberum veto, which meant basically that at any time, any member of the assembly could veto the proceedings and immediately bring an end to the assembly and void all the decisions it had made. And as you can imagine, the Polish parliament, as a result, did not make many decisions of any kind on anything during the 18th century, and they paid for it. So those are kind of the alternatives. And yeah, I think it's about sort of acceptance of these majority decisions as legitimate and the ability of opponents to hold up reforms, even if it's just a few people.
Hello, I'm Tiha. I'm a graduate student in the political science department here.
Yeah.
I'm particularly fascinated by your decision tree about showing like how like these different nobles will choose between whether to do a majority or not, and then how the crown will respond. But I'm particularly interested in the role of the crown here. It seems that regardless of like what kind of legislative institution you choose, or whether any decision that the nobles are making, whether to uphold the majority vote or not, they are all making under this with in mind the lurking actor that is the crown. So like, what is the, like, I want to understand a little bit more about what is the relationship between these different types of nobles and the crown.
Yeah.
So how is the relationship between these nobles and the crown are shaping the type of legislative institution they are choosing, then the type of behavior that they are exhibiting even outside the legislative institution regarding the implementation. So it'll be valuable to know, I think. Thank you.
Yeah, so that one of the things I did not make very clear, and I'm glad you drew attention to it, is that, you know, at least sort of as a stylized factor, at least in most of the cases, most of the time, I think of the crown as a pro-agrarian reform actor. Basically, there were a few reasons for that, but most importantly, fiscal. The crown wanted to protect its rural tax base, and it wanted to have healthy conscripts. So essentially, it wanted to limit noble extraction from the peasantry so that it could get its own share, and hopefully increase that share, and so that it could, you know, recruit an army of non-sickly peasants who could actually fight in wars effectively. So I think of the crown most of the time as a pro-reform actor. It's usually one of the main forces behind agrarian reform, and kind of the winning coalition for reform is I think of it as like a coalition between the crown and a part of the nobility. The reform-minded, and what I also see as usually the more aristocratic part. You are absolutely right, too, that negotiations between government and estates take place kind of in the shadow of the state. And they will talk about this, right? One of the arguments that's advanced for negotiated reform is if we don't do anything, the crown is going to take unilateral action anyway. So better to do this now and at least get reform that we have a say in than have it imposed upon us. And that, you know, indeed does happen in many places. I don't know that It's worth looking into for, I don't see that dynamic as explaining much of the variation in outcomes, because you see it more or less everywhere. And nowhere is it certain too that, if the Crown does decide to act unilaterally, it will be able to, enforce its desires. Because again, it's often the same noble landlords who are voting on these things in Parliament who then have to enforce them, or non-enforce them, as the case may be. And yeah, I mean, I suppose it's not something I can rule out entirely, that there are different sort of perceptions of how effective and how likely Crown unilateral action would be. Worth thinking more about. But for my part, I don't think that explains much of the variation in outcomes. Yeah.
Anybody else here like to ask a question of Brendan? Please.
I have a question regarding the more like conceptual dimension. So like the way you define property right here is like that you include the applications between lords and like peasant, like they're served. So that's kind of like broader than I thought. So like if we apply that definition of property right to like contemporary, like say relationship between employees and employers, like that kind of like also define like what an employer should do for his or her like employees. So I wonder how you like it's like how do you like can you say a bit more about like how you justify this reconceptualization, if I understand it right?
No, you understand it correctly. And it's it comes across as curious or unfamiliar because it is a category of property rights that doesn't much exist anymore, just as many other types of property rights that were prominent in the Middle Ages and early modern Europe. Property rights in office, buying offices, for instance, de jure don't exist anymore. Again, the fact that it's de jure is important too, right? And that really is the basis of my claim for calling these property rights. I mean, pragmatically, like, there's no doubt they're property rights because there were property lawyers back then who said these are property rights, and the nobles talked about them in that way, and the crown talked about them in that way, and the peasants talked about them in that way, at least when they wanted to, improve their end of the bargain and try and advance their claims. I shouldn't say bargain, certainly not a bargain, not a contract. But yeah, so that's why it comes across probably as pretty unusual. It's a type of property right that doesn't much exist anymore, but one that has existed in many societies historically, and Eastern Europe in the 18th century is among them.
Hello, my name is Enrique Kopitke. In your presentation, you briefly talked about how pro-development coalitions can become anti-development coalitions. So first question is, how do you see this happen in the Livonia case or in any other case? How do you see this happening? You said degeneration maybe. And did this noble people in Livonia back in the day, did they frame their arguments or their rhetoric around? They probably didn't use the word development, right? I saw it once talk about public peace. So how did they frame this sort of this argument?
Yeah, so I'll answer the second question first. They do not use the word development in the kind of sense that economists or political economists or economic historians talk about it now. But it's very clear that there is a conception of dynamic, self-sustaining economic growth of population, growth of agricultural output and productivity, growth of trade. I mean, that's kind of one of the ideas behind the reforms in many cases is, well, this is how you get what they would call, a prosperous, well-ordered state, or a state that is, think of it in different terms, a state that can actually compete in, global commercial competition and military competition against its rivals. So they don't use the word development in any language, I think, but I would argue at least that they have a concept of economic development that is not all that different from ours today, and certainly only sort of a step removed from that of the classical economists a generation later, and their critics. So on the first question, yeah. I guess one of the points I'm trying to argue, or that I think I'm going to argue in the book, is that these types of manageable representative institutions, one of the things they can do is prevent, or at least make it less likely, that a pro-developmental coalition will degenerate into an anti-regime coalition, anti-developmental coalition. And that is because they can act as sort of markets or clearinghouses for the exchange of property rights. So if, the Crown, for instance, again, this is going to be very stylized, so it's possible that it does not play out this way at all in practice in these cases. But at least the kind of theoretical insight or supposition here is that if you have a set of property rights that, at one time serve the purpose of economic development and then they become fetters, you have institutions that can get rid of them, or at least that have a better chance of getting rid of them. Similarly, if basically the Crown is allocating estates or whatever offices on the basis of kind of cronyism or perceived loyalty, these institutions open the possibility of rent redistribution that it's possible, at least could arrive at a more efficient allocation. It's kind of Coasian exchange that's going on here, or a quasi-Coasian exchange. But I should emphasize that that part of the theory and the evidence is very speculative so far, something that I will be exploring further.
Okay, great. Just want to make maybe one comment kind of in response to the discussion before we wrap up, which is that, maybe one implication of all of this and one direction to think about, kind of for all of us here too, is that property rights is maybe sort of a stretched concept, if you will, that we kind of tend to impose these grand conceptual unities on the world, like property rights, democracy, the state. But there's so much heterogeneity in what they mean in different times and places, that these kind of master theories we have that try to say, well, here's how property rights come about, kind of need to be we really need to disaggregate what it even means to be talking about each of these kind of grand outcomes at a particular point in time. And at one level, you're telling us something theoretically about something that certainly can fit under the umbrella concept of property rights, but at another level, you're telling us about the history of the abolishment of serfdom. And that in and of itself is just monumentally important, and doesn't necessarily have to be hostage to existing theories or those conceptual stretchings. It's kind of worth pondering, I think.
Yeah, and I'm not claiming that. I mean, I think it's enough to say that I'm aiming to explain. I mean, you could apply it perhaps to the rise of serfdom in early modern Eastern Europe as well, but I am trying fairly concretely to explain the kind of gradual dismantling in different ways of serfdom in this one region of the world over the course of like 100 years. I don't make any claims that this applies to all systems of labor coercion that have existed throughout human history in many different forms, certainly not. I think it's important enough and that it can stand on its own as an account of Eastern European serfdom.
That's really terrific. So one last programming note. So we will be meeting again next week, entirely virtually. We will not be in person. But we're going to be having our next, what we call our Flashpoint program. And so next week, this time, we'll be talking about Afghanistan. So that will be next week at 4 p.m. And then the next time we gather in person at this point will also be for a Flashpoint session on Nicaragua, kind of in tandem with the elections coming up there, which will be on November 9th. So hopefully people will be here next week virtually for the Afghanistan session. And then November 9th, as many as possible to come in person for our session on Nicaragua. But most importantly, I want to thank Brendan McElroy for a really remarkable presentation, tremendous historical command, really, really great. Great questions as well from the audience. Yeah, go ahead.
Can I add, I'm realizing, I mean, it's been on my mind all along that I have not really said a word about the threat of revolution. So if you're curious about that as an alternative explanation, talk to me. I mean, we're going to end this now,
Right.
I assume, but something that I have thought about, I assure you.
Absolutely. Threat of revolution will matter throughout the year and throughout all of history. I think that does matter. Okay, well, great. Well, please join me in thanking Brendan McElroy for a wonderful presentation, and see you all soon.